for leave to adduce fresh evidence that was available but which you could not reach at the material time. And if you give justifiable reasons, as in this case, Okah's case, for instance, where the issue had to do with bureaucratic bottlenecks, maybe visa or things like not being able to present witnesses or documentary evidence, some that had to be obtained from the Ministry of Justice and all that, I think any reasonable court would allow you, because it's a criminal matter that deals with the freedom of an individual. So it's possible.
So you still see a window of opportunity for the defense to be able to present some of their weaknesses?
Very big room, especially when the allegation is, I was not allowed to present my own case in a criminal matter. The law, although, as GT said, it's a strict liability offense. And here is a situation where it's not as if he never had an opportunity to present a defense. He was there. Strategically, he refused to testify on his behalf. He wanted some other persons to come and testify. Now, it was a strategy that went awry. I want, the good point for Mr. Okah is that is somebody I see who claims to be principled. And maybe the defense team felt that putting this kind of person in the witness box will damage his case more than, helping him. Because he will go in there and say things, because he is very passionate about his principles, about what he's fighting for. And so he will not help himself. So they left him out. But to all intents and purposes, if he can marshal his points, get all the details to show that I could have done this, he has a world of opportunity to put in some defense. You
did say something about saying that the Nigerian government cannot ask for, or it might not be exactly right for them, exactly for them to ask for an extradition, especially to come and serve, say, the sentence here when they did nothing about the trial in the very first instance. But if you look at the trial of his accomplices here in Nigeria, GTD pointed out they were found guilty on charges of terrorism, treason, beg your pardon, while that of Henry Okah was on terrorism. Do you think that in itself also goes to show that they believe in what the South African court has done?
You mean the federal government?
Yes.
Well, if the purpose of asking for extradition is to try him for something else.
They haven't asked for it.
They haven't. But if for instance, the reason why is not for the purpose of putting him in jail so that he can serve his time in a Nigerian, I believe no reasonable person will want to serve time in a Nigerian jail. When you are in South African jail, I don't think any reasonable Nigerian will want to do that. But if the sole reason is for the purpose of him facing another set of charges.
Is it possible? Can you face two sets of charges? In two different countries.
For instance, why not?
One relate to one event.
Why not? If for instance the issue in South Africa is this is terrorism, and that's why we have jurisdiction. We have jurisdiction because there is an international agreement that says once what you are complaining of is an act of terrorism or threat of terrorism, then any country has an obligation to try and punish that person for good cause. They've tried him for that, and they found him guilty of even threatening the South African government, because most people are not even looking at that particular charge, that he actually uttered threats against the South African government.
Was he the one that uttered the threats?
Well, that's what the judge said, that he was found guilty of threatening the South African government. And so that gives them enough jurisdiction.
Do you think if Henry Okah was given room, as Justice Keyamo said yesterday, he was given room to defend himself or to call witnesses, would there have been a difference? Do you think the sentence or the judgment would have been different?
I think I'll put the question this way. You said if he was given room.
Because they're claiming that he wasn't allowed to defend himself.
That's Justice Keyamo. That's Okah's lawyer. You understand? As a lawyer to a person, you are bound. You are supposed to advance his cause. Now, the position of the judge is that, you see, when you talk of giving an opportunity, it's not open-ended. It's not forever. It's only in Nigeria that you have a situation where every reason whatsoever will be adduced why a case should not go on. But the question is, was he afforded an opportunity to call his witnesses? Did he take advantage of that? I mean, the standard there is different from our standards. So we may, from a Nigerian perspective, you may say, oh, he's not been given an opportunity. But from a South African perspective, opportunity is not open-ended. Because when you are talking about justice, you look at justice to Okah and justice to the prosecuting party.
As well.
So that it's both sides. It's only in Nigeria that in the name of, oh, because it's a criminal matter, we have to afford the accused person an opposition. So, but now, to answer your question, if indeed it is found as a fact that he was not given adequate opportunity, because I maintain that he was given opportunity. It's not as if as soon as the prosecution closed this case, they said, okay, now we are going on with judgment. No. The important thing is, was the case ever adjourned for defense to present its case? If it was, that's an opportunity. It doesn't have to be 1 year, 2 years. It could be 1 week, 2 weeks, 3 weeks.
Okay, hold on.
Yeah.
He said he wrote to the Attorney General's office.
Yes, Nigeria.
Who directed him, Okah's counsel in South Africa, to apply for legal assistance from the Attorney General's office in Nigeria. Now, he maintains that the South African court did not accord enough time to facilitate that directive.
Did he define is enough time? How long? Is it 1 week, 2 weeks, 1 month?
How long do you think would have been adequate? Because there has to be visa arrangement for witnesses to go down and all that.
Now, when you talk of legal aid, legal aid to me probably means as in getting a lawyer to represent him. That's my own understanding of legal aid. If it's legal aid about presenting witnesses, that would not qualify as legal aid. Calling your witnesses is your private job. It's what you have to work about. I mean, you know that you've been given a date. You have to present if the witnesses are coming from Nigeria, you have to if they can show that the South African embassy here, I mean, went out of its way to prevent these witnesses from obtaining the requisite visa to enter into South Africa, that would be justifiable ground for setting aside the judgment, so that the case will be reopened for trial at the lower court.
Okay. What makes you a political detainee or a freedom fighter and not a terrorist? Because some activists, especially in South Africa, on that day came up with placards. Some of them read, Henry Okah is a political detainee and not a terrorist. And another, Henry Okah's trial reenacts Rivonia trial of 1964.
Good. Now, I'll just look at two different persons. For instance, MK Abiola, to me, was a political detainee. He was detained strictly because of his political position, strictly because he claimed that he had a mandate of the Nigerian people to rule. Now, but the moment you cross the line, the moment you now start telling people, you see, one thing GT said, and which most people who are on the other side of the divide seem to overlook, is this. You have a situation where you have charges hanging on your neck, offenses of strict liability. The prosecution presents a case, one side of the divide, one side of the scale. You did not present anything. You are saying, oh, I was not given ample opportunity. Now, Okah never, when I was listening to the report of your political correspondent, I believe all she said,
Judiciary.
Sir?
Of the judiciary correspondent.
Sorry. Now, all she said was that, oh, Okah was this, the leader of men, about leader of men, this, and that. Now, if these are findings of the court, then he's a terrorist. If indeed you sponsor, you claim to be the leader of an organization that claimed to have bombed, killed Nigerians, of an organization that threatens another government, then you are a terrorist. You are not a political detainee, because you have crossed the bounds. You've stopped fighting, for a cause which you believe in, and you are using a peaceful means for fighting it.
So does the means matter? Because at the end of the day, it is the reason.
Yes.
Is it not the reason that we should be looking